But as recent tragic events have demonstrated, all tools need to be periodically sharpened. The tools in the Mine Act and the OSH Act are no exception. I'd like to focus today on several provisions in H.R. 5633 that will, if enacted, sharpen our enforcement tools and help make our mines and other workplaces healthier and safer places to work. Under the Mine Act, an operator with significant and substantial violations can be subject to increasingly severe enforcement actions, including withdrawal orders. Although Congress did not define significant and substantial in 1977 when it passed the Mine Act, MSHA and the Solicitor's Office believe the phrase applies to all violations that have a reasonable possibility of resulting in injury, illness, or death, and excludes only violations that either present no hazard or violations in which the hazard is speculative or remote. We believe this interpretation is consistent with the legislative history of the Mine Act. Unfortunately, the Federal Mine Health and Safety Review Commission does not agree and has established a four-part test for S&S, which in our view has hampered enforcement for many years. Violations under the Commission-imposed standard must rise nearly to a level of imminent danger before they're considered S&S. I've given several examples of these cases in my written testimony. Section 201 of the bill would more closely reflect what we believe was Congress's original intent by defining an S&S violation as one in which there is a reasonable possibility that such violation could result in injury, illness, or death. We support this streamlined definition, which we think will provide a clearer standard for operators, enhance mine health and safety, and reduce counterproductive litigation over whether a particular violation is indeed S&S. Mine safety and effective enforcement will also be enhanced by the bill's amendment to the Mine Act injunction relief provisions. Section 1082 of the Act authorizes the Secretary to ask a federal district court for appropriate relief, including a temporary or permanent injunction, if she believes that the operator of a mine has engaged in, quote, a pattern of violations of mandatory health or safety standards that constitutes a continuing hazard to the health and safety of miners. This provision has provided two difficulties. First, it requires the Secretary to establish a pattern, a term that closely echoes the term pattern in Section 104E's pattern of violations provision, which, as Assistant Secretary Main has described, has proved difficult to apply and to enforce. Second, it limits the basis for the pattern to violations of mandatory health and safety standards. Section 203 of the bill addresses these issues. It replaces the term pattern with the phrase course of conduct, and it specifies that the behavior that would support injunctive relief is not limited merely to violations of mandatory health and safety standards, but it includes other things like violations of orders. A third welcome provision in the bill is the provision expanding the Secretary's authority to issue subpoenas for the purpose of taking testimony and other evidence. Currently, that power is only given in conjunction with public hearings. Section 102 of the bill would authorize the Secretary to issue subpoenas in conjunction with the performance of any of her functions. It would also authorize MSHA representatives and attorneys to question individuals privately, to take an individual's confidential statement outside the presence of the operator's attorney if the individual so desires, and to maintain the confidentiality of that statement to the extent permitted by law. The bill also adds two new criminal provisions to the Mine Act and strengthens both the Mine Act's and OSH Act's current sanctions for criminal conduct. The bill would amend the Mine Act so that giving advance notice of MSHA inspections would be treated with the severity it deserves. Advance notice prevents MSHA inspectors from being able to observe the mining as it's actually occurring. The bill would make such conduct, which is currently treated as a misdemeanor, a felony. The bill would also provide a brand new criminal provision making it a felony to retaliate against any person, miner or non-miner, who reports unsafe conditions to MSHA. Such conduct would be subject to the fine set forth in the code and would carry a maximum prison term of 10 years. This provision would encourage miners, their relatives, and others to notify the government of mine safety violations by assuring them that retaliation for acting would be met with effective punishment. Now, both the Mine Act and the OSH Act already contain some criminal provisions. However, most of these violations are treated as misdemeanors. Building on that foundation, the bill would analyze all such violations by individuals, operators, and employers under a knowing standard and would raise the maximum penalties for knowing violations fourfold and make first-time convictions felonies rather than misdemeanors, which is currently the case. These charges, especially the prospect of a significant period of incarceration, we believe would focus management personnel on their responsibility to keep their minds safe. The bill would also make other important improvements to the OSH Act. And I will mention just two of them. First, it grants rights to accident victims and their families and other representatives. They must be notified. Second, the bill would allow OSHA to require prompt abatement of all serious hazards, even if the employer files a notice of contents. And Assistant Secretary Michael's testimony will explain the importance of that. So I appreciate the opportunity to testify on this important legislation. As Secretary Solis said when the bill was introduced, there's a tremendous need for this legislation in order to save the lives and health of American workers in mines and throughout the nation. And I look forward to your questions.